So I wanted to give a very quick reaction to the oral arguments for the United States Supreme Court case concerning Colorado removing Donald Trump from the ballot. I'm extremely familiar with this case and the law involved. I've been following the case very closely because it's quite interesting. I've read all the amicus briefs submitted for the case, where experts on both sides of the argument have provided evidence for why it should be decided a certain way, and I've listened to and read a lot of commentary outside those briefs, and even come up with some of my own arguments, some of which were actually brought up by the justices themselves, even though I've never heard anyone else making them, so it'll be very easy for me to elaborate on some of the points that were made today. So based on reviewing the arguments on both sides, my conclusion was definitely that the case against Donald Trump was very strong. However, the prevailing opinion has been that the Supreme Court was going to find a way to weasel out of applying the law for various political and practical reasons, and I was very curious to see exactly what route they would go down. And it looks like they're leaning towards saying that Section 3 must be enforced by an act of Congress, which is not a great option because it makes possible a really horrific scenario where Donald Trump wins the election and then is disqualified by Congress before actually taking up the office. And then at that point, there's disagreement about whether his VP pick would become president or whether we'd have to do an emergency special election or what. So the Supreme Court would ostensibly be staying out of the November election by making it Congress's problem, but they'd actually be secretly hoping that Donald Trump loses the election because otherwise that could put them and the country in a really bad spot. Now, the way to avoid that scenario is by ruling that the president isn't, quote, an officer of the United States. I had the text of Section 3 of the 14th Amendment on the screen for you. So this is the basis for saying Donald Trump should be removed from the ballots because he's not qualified under this section of the Constitution. Section 3 basically says that if you take an oath as a public officer to support the Constitution and then engage in insurrection, then you violated your oath and cannot serve in public office again. So January 6th was an insurrection. Donald Trump engaged in it. Therefore, he can't be president again. Therefore, he shouldn't appear on presidential ballots. That's the logic of the original case. But there's this specific language used in Section 3 that says that the oath you have to violate to be disqualified is one held as, quote, an officer of the United States. And the Constitution is a little ambiguous about what positions are offices, and it's possible that the president somehow holds an office but is not an officer. Now, what's really interesting is that for most people running for president, this distinction wouldn't matter at all in the case of Section 3. It's only because Donald Trump is just like the second or maybe third person in U.S. history who ran for president without first serving as some kind of officer that this distinction is relevant. So claiming he's not an officer is sort of a loophole that applies only to him and lets him get out of Section 3 enforcement. And that's why it's kind of tempting for the Supreme Court to accept this argument that the president is not an officer, because it lets the court ignore Section 3 this one time without actually defanging it or reinterpreting it for the future. But what sort of intrigued me was that really didn't seem to be where the court was going in today's oral arguments. The justices left open the possibility of using this reasoning, but just from their tone, how long they waited to get to this argument, and them referencing most of the counter-arguments against it, I got the impression that they didn't take this officer distinction very seriously. Even Neil Gorsuch opened on the topic with the starting textualist argument that saying, someone can't hold an office and yet not be an officer just contradicts the plain understanding of those terms in the English language, which of course it does. But again, that's odd because the officer argument is the option of least harm for the court, in that they can make this case go away just for Trump without commenting on any part of other part of the case or the law. So I expected them not to attack the officer argument at all if they wanted to use it, because it's weak enough as it is. It doesn't need any help from the justices to make it look any worse. But what was also interesting in the arguments was just how upfront the justices were with being motivated by practical considerations. In theory, the Supreme Court is supposed to be just a body that interprets the law. They're not, but they often try to convey the impression that they make decisions without regard for the potential negative consequences. And the Supreme Court has made decisions in the past, Brown v. Board of Education, Roe v. Wade, Bush v. Gore, that were extremely controversial to people at the time. But, they rationalized it on the grounds that they were just, quote, following the law. But in today's oral arguments, they were just full mask off. Justice John Roberts and Sam Alito seemed very concerned about tit-for-tat retaliation, against Joe Biden, for example. Some states will invoke Section 3 against him. If we let Colorado take Donald Trump off the ballot, Alito and Kagan were both very concerned about creating consistency between states. We've got to have, national candidates on the ballot in every state or off the ballot in every state, even though the legal basis for trying to force consistency between the states for national elections is incredibly weak. That's very hard to justify. Justice Gorsuch brought up the hypothetical of orders of a president being ignored by the subordinates, that the subordinates thought they were an insurrectionist. The section says that you cannot hold an office, so presumably if a president commits insurrection, then he's immediately disqualified. Nothing else he does has legal weight anymore, and presumably officers in the military or something wouldn't have to listen to his orders anymore. So this is just an example of a serious practical problem that arises from ruling against Donald Trump in this case. So they were very upfront about this. There was a constant background of, wow, this would create a lot of practical problems we don't really want to have to deal with, but with not a lot of attempt to legally justify the rulings that would let the court avoid those problems. And something that I think was under-addressed during arguments was that, in my opinion, the court really has no way of getting out of dealing with a lot of messiness the way they seem to think they can. For example, Brett Kavanaugh put forward the theory that part of congressional enforcement of Section 3 is through the criminal insurrection statute, 18 U.S.C. 2383. I'll put that up for you on the screen. This is not a great argument because 2383 actually predates Section 3. I mean, some people seem to suggest that it's after. Their history seems to be wrong on that. It predates Section 3, so it can't really have been intended as an enforcement mechanism for Section 3, but it would be nice if it did. It would help this particular argument. But the thing is that if Donald Trump was ever charged with 2383, that conviction simply would be appealed to the Supreme Court because it's very, very rarely been used. In fact, I haven't seen one example of a case where it was actually used in establishing any kind of precedent for what insurrection means in the context of the statute. So the court would be forced to rule on what an insurrection was and did Donald Trump engage in it, and also is this 2383 statute, is it even constitutional because it's adding a qualification to office, because the last line is that it bars people from holding future office. So they basically have to address all the things that they're avoiding addressing in this case if that was their solution. So it's a solution that's really not a solution. Similarly, Jack Smith's January 6th case is ultimately going to be appealed to the Supreme Court as well, in which case the court may be forced to concede that Donald Trump engaged in many, insurrection-like activities, obstructing a proceeding, defrauding the United States. And so trying to dodge the insurrection question in this Section 3 case is kind of just delaying the inevitable for them, in my opinion. But maybe they're just really hoping Donald Trump will die before the trial finishes, or some other externality is going to save them having to rule against him in ways that people don't like. I'm not sure exactly what their thinking is, but the root of saying that Section 3 must be enforced by an act of Congress itself is extremely messy. You could get a scenario, for example, where Donald Trump is elected, but Democrats control both houses and they pass legislation that would allow them to remove Donald Trump, but then Donald Trump vetoes it to protect himself. Or maybe legislation gets passed and used on Donald Trump, but then that law is challenged as using an overly broad definition of insurrection, and it's appealed to the Supreme Court on those grounds, and the Supreme Court has to address the issue once again. They can't get out of it. So saying Section 3, that whole argument, though, that line of reasoning, saying Section 3 is not self-executing and requires either an act of Congress or a criminal conviction, always struck me as the weakest argument to make to keep Donald Trump on the ballot. It's actually really easy to argue what an insurrection is and say that he didn't engage in it. That would actually be the easiest legal argument to make, but it's just a really politically fraught one. Using the officer argument is not great, but it's practically really good. But saying Section 3 is not self-executing is contradicted by the text of the amendment, is contradicted by the history of Section 3's prior application. It violates basic principles of checks and balances and simple logic. Requiring congressional application makes very little sense when they already have an ability to remove Section 3 disqualification by 2/3 vote. That's the last sentence of Section 3. Essentially, if you could get 2/3 of Congress to vote to unban someone, then by definition, you wouldn't even have 1/3 voting to ban them in the first place. And conversely, if you ban someone by simple majority, which is how most legislation happens, most resolutions happen, just 50 plus 1. If you can ban someone through that kind of process, the standard process, then by definition, you don't have the 2/3 to unban them. So having two procedures, both of them inside Congress, seems to make no sense. You either need only one or the other, and one of them is specified in the text of Section 3. So, for example, it would be very feasible for Congress to ban Donald Trump right now by a simple majority vote. You might be able to get enough votes to do that, or maybe just shortly after the next election, you would have enough votes to do that. And then there's no way you'd be able to get the 2/3 to unban him. So it would be so easy to ban someone this way. It really begs the question of why you would need an official procedure to enact the ban instead of it just being the default. And of course, historically, it makes no sense that such a process would be necessary because at the time of the Civil War, there were so many people that needed to be banned that it would have been extremely impractical to require a vote for every single insurrectionist candidate who wanted to run, which was hundreds of people. Anyway, I think that's all I have to say about the case for now. I really would have expected the justices to lean more on the officer argument rather than pushing for congressional enforcement. Congressional enforcement sort of seems like it's more legally justified and less political, but really I think it's harder to legally justify and has much more serious practical consequences. And I didn't expect the justices to be in such a gambling mood as to roll the dice on congressional enforcement and just hope it doesn't become a problem for them, because there's a high risk of that happening. But we'll see how they end up justifying it. With enough clarification, maybe they can make it make sense. But it seems like they're looking for a solution where states can't adjudicate Section 3. They want national elections to be national, and yet they don't want to be adjudicating it. They're not comfortable with that position, and yet leaving it to Congress is a real nightmare. And so it's not clear how they're going to square the circle on those competing concerns they have. I'm really really curious to see what they pull out of their rear. Thanks for listening.